Students, let us discuss about meeting and what are the requisites of a valid meeting. When two or more than persons get together at one place to discuss any common issue, it is called a meeting. In a company, meetings happen between various members, directors, creditors, etc. For example, meetings of the shareholders or of the directors or debenture holders. These meetings must be conducted in compliance with the rules and provisions of the Companies Act 2013. What are the requisites of a valid meeting? Let us discuss. A meeting should be conducted by following the procedure provided in the articles and the act. It must satisfy the following conditions to validly transact a business. The requisites of a valid meeting: first, must be convened properly, must be constituted legally, must be conducted properly. Let us discuss one by one. It should be convened properly. A meeting which is properly convened by the proper authority and conducted after giving a proper notice to all the individuals who are supposed to attend the meeting is a valid meeting. Proper authority. Meeting is stated valid if it is called by a proper authority. Following are the proper authorities to call the meetings. Board of Directors. Board of Directors of a company is empowered by the Articles of Association of a company and common law to convene a meeting. An individual director cannot call a general meeting. A board meeting is stated unlawful and the notice for the general meeting becomes invalid if few directors conduct a board meeting without allowing other directors who were freely available at the office to the meeting. A secretary cannot convene a general meeting without proper authority, but the notice can be ratified before meeting by the board. Members are requisitionists under section 100 are eligible to call a meeting if the directors don't call a meeting. The tribunal under section 97 is also eligible to call a general meeting on a petition of any member. It has been conferred with the same powers to call an EGM but on a petition of any director, suo motu, and any member. This power can only be exercised when it is impracticable to hold, call, or conduct a meeting. A meeting conducted in such a way is deemed to be a meeting which is duly called and conducted. Notice section 101. Notice is a document containing various details regarding meeting such as time, date, day and venue where business to be transacted at the meeting. It is sent to the persons who are entitled to receive a notice to the meeting to the address provided by them. A valid notice is a notice which complies with the rules laid down in the Articles and Companies Act and also complies with the general rules. Now let us discuss about the second aspect: must be constituted legally. Quorum, section 103. Quorum implies to the minimum number of members required to conduct and validate a meeting. According to section 103 of the Companies Act 2013, quorum required for any other company is minimum of 2 members, whereas under articles it is prescribed that quorum shall be more than 1. Following is the quorum prescribed in section 103 of the Companies Act 2013 for public companies. If number of members present on the date of meeting is less than 1000, then the quorum required is 5. If number of members present is more than 1000 but lesser than 5000, then the quorum required is 15. If number of members present is more than 5000, then the quorum required is 30. Chairman of meeting. Chairman is the top authority of the company's board who is elected or appointed for conducting or handling board meeting. Directors and auditors. Directors. If a director fails to attend the meeting, his absence is explained by the chairman. On his behalf, the chairman of the audit committee, stakeholders, relationship committee, nomination and remuneration committee, and any other member of such committee who is authorized by the chairman can attend the general meeting. Auditors or their authorized representatives can attend the general meeting. Secretarial auditor. A secretarial auditor or his authorized representative can attend the annual general meeting unless exempted by the company. Must be conducted properly. A properly conducted meeting is one which follows proper rules. Ascertaining the sense of the general meeting. Harmony before a meeting is not obtained on all matters. The chairman would like to acknowledge the opinion of the people in the meeting. This process is called ascertaining the sense of the house. For this, the chairman puts forth the matter to vote and the members convey their approval or disapproval. The following methods are used for ascertaining the sense of the general meeting: by voice vote, by acclamation, by division, by ballot, by show of hands, by poll. Rules as to voting. For equity shareholders in a company limited by shares, every equity shareholder has the right to vote in proportion to their paid up equity capital under section 47 subsection 1a and 47 subsection 1b. For preference shareholders, the preference shareholders are empowered with voting rights only on the resolutions which affect them under section 47(2). Bearer of share warrants. The holders of share warrants enjoy the right to vote if the articles of association of the company allows it. Insolvent. An insolvent shareholder can vote only if his or her name appears in the register of names. Joint holders. The senior among the joint holder is entitled the right to vote. Representation of corporation in meetings. Representative of a company or his proxy can exercise the right to vote in a meeting under section 113. Proxy. A proxy can vote on a poll and is not allowed to vote by the show of hands. Representation of the President and Governor. If the President or Governor of India is a member of a company, then their selected representative acts as a member of the company and it's entitled to various rights and powers along with voting right. Voting by show of hands. In the first instance, section 107, the voting must be done by the show of hands and each member has one vote under section 107. Voting by poll and time for its demand. A poll is demanded when voting by show of hands does not provide accurate results because a proxy cannot vote by show of hands under section 109. It can be demanded on or before result declaration. Resolutions. The term resolution can be defined as any decision taken by the director or other member of the company at the time of annual general meeting. Every company is considered as an artificial person. Any decision by the company would always be in the form of resolution. The Companies Act 2013 not provided any clear definition of the term resolution, but it states various matters and types of resolution can be taken by a company which are required to be passed in the general meeting of a company by its members. Proxy. According to the section 105 of the Companies Act 2013, proxy means a person appointed to represent another person and can vote at the time of meeting on behalf of that person. Basically, the proxy is an instrument through which a person is appointed. Motions. The term motion refers to a proposal which is made by any member at a meeting and passed without making any changes or modifications. The individual who prospers a motion is called the mover and the motion must be signed by him. If the other member thinks that the motion needs few modifications or changes, then an amendment is moved. An amendment is a proposed modification in the wording of the motion. If a motion is passed without amendment, it is called a resolution. The motion must be brought to the meeting in written form and a necessary notice must be given if needed. Minutes. The concept of minutes of meetings is discussed under section 118 of Companies Act 2013. Minutes refers to the official record of the company meetings, all board meetings and AGMs. The concept of minutes of meeting is discussed under section 118 of Companies Act 2013. Minutes refers to the official record of the company meetings. The minutes of meeting are the summary of complete meeting conducted with shareholders and directors in which discussions are made, decisions are taken and resolution arrived. Thus, minutes of meeting considered as the complete summary report of the conducted company meetings. Thank you. Proxy How is proxy appointed? What are the rights and disabilities of proxy? How proxy is revocable? Proxy. According to Section 105 of Companies Act 2013, proxy means a person appointed to represent another person and can vote at the time of meeting on behalf of that person. Basically, the proxy is an instrument through which a person is appointed. According to Section 105, every member is authorized to appoint a person as proxy in order to attend and vote on behalf of himself, unless articles of the company provides the following. The member of the company who does not have shares cannot appoint a proxy. The member of a private company cannot appoint more than one proxy. The member of public company can appoint more than one proxy. The person who is appointed cannot vote except on a poll. The instrument used to appoint a proxy should be submitted to the company within 48 hours before the meeting. The instrument used to appoint proxy should be in writing in the form prescribed and signed by the appointer or by his attorney. According to Rule 19, appointment of proxy shall be in the form number MGT 11. Rights of proxy. The rights of a proxy are listed below. Under Section 109, a proxy can deem to poll. Proxy can vote only on a poll. Proxy can use his vote in different ways. Disabilities of proxy. Proxy does not have the right to speak in meetings. Proxy cannot take part in discussion during meeting. Proxy cannot raise his question in writing and cannot send it to chairman for answer. Proxy does not be counted for the purpose of quorum. Proxy does not have the right of inspection either for proxy firms or for the minutes of general meeting. Revocation of proxy. Revocation means cancellation or taking back. Proxy's nature is revocable in the company. Proxy can be revoked at any time before he or she votes. The proxy who is appointed earlier can be revoked if one more proxy is appointed at later date. For example, if two or more proxies are appointed by the same holder with respect of same shares, the proxy who is appointed on the latest date will replace the proxy appointed on earlier date. However, if both proxies are appointed on the same date or does not have any appointed date, then both proxies will be removed. In some cases, if member of a company is died who has appointed his proxy before his death, then such proxy is revoked. However, such proxy's vote is valid till companies get the information regarding the death of the company's member. Addition to this, proxy is also revoked in the situation where shareholder is personally given the right to vote in the meeting. Accordingly, if the revocation is communicated to the proxy before the poll but not before the meeting, then such revocation will be ineffective and proxy can vote in that meeting. For this situation, there is no provision under the articles as such the power of revocation would get unburdened. For example, if proxy voted in the first poll and was revoked before final poll, then due to the absence of any article, the revocation will be ineffective. Thank you.